Good morning, everyone, and welcome to Kelly Santini's webinar in relation to the changes to Rule 76 of Simplified Procedure. My name is Samantha Iturregui. I'm a partner with Kelly Santini's Litigation Defense Group, and I'm here with Sarah Reich, who is an articling student with our firm, as well as Jennifer Therrien, who is an associate with the firm, and Kate Agyemang, also an associate with the firm. And so Jen, Kate, Sarah, and I are going to spend the next 45 minutes or so talking about the changes that have come into force as of January 1st of this year. We're going to start off with Sarah talking to us about the pre-litigation considerations, followed by Kate, who will talk to us about the pre-trial considerations. And then Jen is going to speak to the trial considerations. At the end of those presentations, I will come back on and talk to you a little bit about the major takeaways and how these are going to affect us going forward. If you have any questions during the presentation, please feel free to use the dialog box and to send in your question, and we will do our best to get to those. Also, you can download these slides via the dialog box. And if at any point in time you have difficulty using the dialog box, please just send us an email and we'll be sure to send over the slides to you and answer any questions that you might have. So the changes that came into effect January 1st of this year are quite substantial, and they're going to have a significant impact on litigation going forward. So I'm going to pass it over to Sarah now to talk to you about the pre-litigation considerations.
All right, thank you, Samantha. These new amendments to Rule 76 will have a significant impact on the evaluation of claims, settlement, and any litigation that may follow. Firstly, these amendments have increased the monetary jurisdiction from $100,000 to $200,000. However, the maximum of $200,000 is per plaintiff or as against each defendant. Thus, the global amount of these cases may be much higher. At the same time, the monetary jurisdiction of the small claims court has also increased from $25,000 to $35,000. Thus, as of January 1st, claims brought between $35,000 to $200,000 may be commenced using simplified procedure. Cases commenced prior to January 1st under the ordinary procedure, claiming for between $100,000 to $200,000 will not be automatically transferred into simplified procedure. In addition, these new changes have limited parties' ability to recover costs to a maximum of $50,000 and disbursements to a maximum of $25,000, both exclusive of HST. Now, this is with the exception of any cost consequences for misuse of or failure to use the simplified procedure. So if plaintiffs do not commence their claims by using simplified procedure and it's later determined that this is the avenue they should have proceeded under, they may not be awarded any costs and may also be required to pay all or part of the defendant's costs. These new costs and disbursements regime will not apply to actions that were commenced prior to January 1st. These new changes are a significant change to Rule 76, as previously there were no limits placed on cost and disbursement awards under Rule 76. Kate will now be discussing the pre-trial considerations.
Good morning, everyone. I'm really pleased that you're joining us on this Friday morning to talk about simplified procedure. You're all very brave, so we're really grateful to have you in with us today. So as Sarah said, with all of these changes, we're going to see ideally probably more jurisdiction is being more cases. So now that it's gone up to 200,000 and small claims is up to 35,000, we're going to see simplified procedure coming up more, particularly now that the cost consequences are going to be an issue. That's something to consider again when it's capped up to this 50,000 outside of these penalties. This is something that we're going to see is plaintiff counsel is going to need to be very specific about what they're claiming for and where they're claiming. And that will also change how we negotiate and look at files. And Samantha will speak to that more later. But when we look at the pretrial considerations specifically, because as of January 1, these changes basically mean the summary trial procedure has been revoked and all simplified procedure trials will follow this new path. This new path has some things that were there before and are being enforced and some new things outright. And these are just things that we're going to keep in mind as we go so that we're always one step ahead and know what's happening next. So a few of the things we're going to talk about here are the use of experts, a new pretrial conference kind of overhaul, as well as a newly required proposed trial management plan, and the fact that trials are not to exceed 5 days. So with this new procedure, one thing to consider is, so oral examinations, the time limit for conducting these oral examinations has increased from 2 to 3 hours. So while it's a marginal increase, more time is going to be important to get the information we need. So when we're looking at more cases in this area, counsel now will at least have one additional hour to go through that. But again, for nuanced files, 3 hours in examinations is going to be very difficult to get a sense of the full details, particularly an injury in that. So this is going to change how we use our time the most judicially. Once we get into the pretrial conferences themselves, parties actually now need to schedule the pretrial conference within 180 days of the notice of intent to defend or statement of defense. This is a major increase from the 45 days. So that means that we'll have a little bit more time to schedule those conferences. However, what we're going to need to do beforehand and up to that has extended, which accounts for why this time has been expanded. One of the major things that's come up again is that experts have also changed. Experts were always limited, but now they are limited to 3 experts per party, and their evidence is now admitted by way of affidavit. So this means that there's not the same kind of live evidence that we would necessarily have, and reports and the affidavits bringing those reports into direct evidence are going to be even more scrutinized than they were before. In doing that, for the scheduling aspects of their pretrial conference, it's also to note that the registrar previously served those notices, but now the parties are scheduling them, and the parties actually must agree to that date and do so within that 180 days. So again, that will give some, hopefully avoid some delays where counsel is just not available and avoid adjournments. But again, counsel will have to agree, and they will need to see how that actually plays out in real life. Moving on to the pretrial considerations, timelines, there's more aspects that we need to consider. So 30 days prior to the pretrial conference, all parties now must also agree to prepare a trial management plan. So the trial management plan is a new document. It's not something that we necessarily would have had to provide before. Certainly it would have been created behind the scenes with counsel. This is how we prepare for trial. However, this trial management plan is now something that parties have to agree to and submit before the pretrial conference. So this is going to get counsel talking more readily and sharing that process more ahead of time. So again, this trial management plan is going to need to deal with listing every witness, including the expert witnesses, set the time allocated to examine and cross each, and also discuss the time allocated to opening statements and to arguments themselves. So the idea is that by the time you're actually getting to the pretrial conference, that the process of what this is going to look like, the issues that are coming up, the witnesses that are speaking to same, have been agreed to beforehand. And then once we get just 5 days before the pretrial conference, there's various documents that need to be filed. So again, that's the proposed trial management plan, the affidavit of documents, copies of the expert affidavits that append the actual reports as well, and copies of any other documents that are going to be relied upon. This isn't, again, in the preparation that we would typically do for a pretrial conference, we would typically take these steps, but now the timelines are changed. There's new documents that must be agreed to between counsel. And interestingly, there will also need to be, the statements of the parties, setting out all of the positions and the parties' positions in that at issue. The idea is to get that communication going and agreed upon, so the pretrial conference is used more readily to move the matter forward. I'm going to turn it over now just to Jen after this role of the judge. Just bearing in mind that the role of the judge in that pretrial, again, will be fairly similar, but it will be to, again, set the number of witnesses other than whose evidence may be adduced, set the dates for the delivery of those witness affidavits, and again, set down a trial date. Of note, they now approve or modify the trial management plan. So if there's any sort of dispute or it doesn't look realistic, they are going to move that forward. This is under the caveat, though, that the judge will have no discretion to move the trial beyond 5 days. So that new trial timeline limit of 5 days is going to be there, whether the judge agrees with it or not. It seems at this point, we do have some concerns about how that's going to work for some of our father-bin sessions, but we'll talk about that a little bit more later.
All right, so in terms of trial considerations, as Kate mentioned, there's a restriction of 5 days. However, if the trial management plan states that you and counsel, or both counsels, anticipated only being 3 days or 2 days and more time was needed, the trial judge has discretion to increase the trial timelines up to 5 days. So you're not stuck to the 2 days necessarily, or whatever you say in the trial management plan. There is some wiggle room, but only up to the 5 days, which I think is significant here, especially if you have, thinking of a personal injury action where you have 3 experts on each side, getting that evidence done in 5 days. Although the direct evidence is being put in by way of an affidavit, cross-examinations can be pretty lengthy for all of those experts, plus the plaintiff. If liability is an issue, then you have likely the defendant being cross-examined as well. So I anticipate that we may see some issues with the 5-day rule, but it's yet to be seen. So before the change of the rules, trials could proceed by way of a summary trial or a regular trial, and there was juries. A big change is that there are no longer juries as of January 1, 2020 under the Simplified Procedure rules. That doesn't apply to cases where a jury notice was filed before January 1, 2020. So just in my own practice, I saw a lot of defense counsel filing their jury notices like December 30th because they're realizing that we may be able to have a jury after that if we didn't do it. And for me, I had to think about whether a jury was really necessary given all these changes in the rules. So we had to have those discussions with our clients. So now you can only proceed by way of a summary trial, which essentially is the same as a trial, but there's no direct evidence. So we wouldn't be examining our own insureds and getting their evidence in that way. It would be done by way of affidavits, and then they would just be cross-examined in the summary trial. There's still opening statements, there's of course still closing arguments, but we're eliminating the direct evidence because that can take quite some time. It's probably the slowest part of trial, and so by putting it by way of affidavit, they're hoping to reduce the timelines, I would assume. There was some confusion as to whether how the rules were going to apply with cases that were already started and are about to go to trial now, whether they're going to have to go by way of summary trial. My colleague and a good friend of mine just had a pre-trial here in Ottawa with Justice Williams, and there, I think, some leeway as to whether direct evidence will be able to be put in and whether the old rules can apply. Because under the old rules, you had a certain number of minutes to put in your direct evidence with your own witness, and so that might still happen for cases that have already started. The vibe that my colleague got was that, there was leeway with those files. And I think it's a learning curve for everyone, including the judges. So that's just something to keep in mind with files that are already ongoing that had already started under the old rules. So, in terms of jury notice in juries, so like I said, they're not permitted anymore unless you've filed a jury notice before January 1, 2020. The exception to that is actions below $200,000 that were started for slander, libel, defamation, malicious prosecution, and false imprisonment. But those actions are started under the ordinary procedure in civil procedure. They're not under simplified procedure in any event. So it doesn't really apply, and it doesn't really apply significantly for insurance defense purposes. But just note that that is an exception to the rule. And if a jury notice on those files is subsequently struck, then those actions come down into simplified procedure. So that's all I have for now. I'll turn it over to Samantha just to talk about some takeaways and answer any questions you guys have.
Okay, well, thank you. So we've now gone through an overview, of the major changes to the rules, and I'd like to talk to you about some that the changes that I feel are going to be the most impactful going forward. And the number one most impactful change to the rules, in my opinion, is the effect that we're going to have of not having a jury on these simplified procedure matters. Now, as defense counsel, I do mostly personal injury matters, and my practice is to file a jury notice on all of these actions. There are exceptions to that rule, but there are very few exceptions. And the reason for filing jury notices on these personal injury matters are because we tend to get a more reasonable assessment of damages from the jury than we would from judge alone, or a lower assessment of damages than we would from judge alone. And so particularly in motor vehicle accident cases where the considerations in relation to damages are twofold. You have to consider threshold and whether or not the plaintiff will meet the statutory threshold to be allowed general damages, which is and has always been the decision of the judge. However, the assessment of damages themselves for general damages was determined by the jury previously. And you know, in addition to the jury determining these damages, we had the jury doesn't necessarily know that there's an insurance party defending the defendant in a motor vehicle accident matter, and they also are not likely aware of the statutory deductible that will apply to general damages here. And so when the assessment comes from the jury, it's a straightforward assessment of the damages based on the evidence put before them. The judges also will have the benefit of this evidence. However, they are aware of the deductible, which in some cases could mean that an assessment of damages, you know, that is relatively small, will have the effect of the plaintiff not receiving any money in the end. And so I think that particularly on motor vehicle accident cases and personal injury matters, the impact of not having a jury is going to be very significant to us going forward, and it's going to be something that we're going to have to consider as insurance defense counsel as we approach trial, because we won't have the benefit of an assessment of damages from the jury. The second most impactful change, in my opinion, is the fact that there's only a 5-day trial that you're able to obtain for these simplified procedure matters, and the impact that that's going to have on the lifespan of these files. Now, this may be a positive for us in that, you know, we're currently waiting years to receive trial dates for cases that are 3 weeks or more, and any jury case, according to the trial management court here in Ottawa, should be scheduled for more than 3 weeks, because in their opinion it can't be done for less than that, and I tend to agree with that. And in most of the cases you can't complete a jury trial on a personal injury matter in less than 3 weeks. So the fact that the trial dates are limited to 5 days may mean that we will get trial dates sooner. I think that's what it will mean. In fact, trial dates will come up more quickly. You might be seeing cases that would have taken 6, maybe 7 years to get to a full trial. We might be able to cut a few years off the lifespan of the litigation by limiting the trial to 5 days. The court will have more availability because they won't be sitting on these lengthy trials, and we'll be able to move it forward more quickly, which I think is a benefit to everyone. Now, Jen mentioned it and Kate mentioned it also, that it's really left to be seen how the courts are going to deal with this 5-day trial rule. It's unclear to me what happens if there simply is the necessity for another day or two of trial. I'm not sure how the court is going to deal with that. It seems to me that there are situations where the time is going to need to be extended. But in our read of the rules currently, as we've seen them, there's no allowance for that. And so as the months go by here, we're going to have to look at that and see how that is dealt with by the courts. The new approach to discoveries is interesting because on the one hand, it extends the amount of time that you have for discoveries from previous simplified procedure matters from 2 hours to 3. However, there are, I think, a lot of new matters that will be brought in simplified procedure now that the limit has been increased that wouldn't have necessarily been brought in simplified procedure previously. And so we're going to be faced with a lot more cases that fall into this group, and being limited to only 3 hours of discovery is going to be challenging. It's going to mean a different type of preparation for discovery, and it's going to mean a different type of reporting to you after discovery, because there may be some information that we're simply not able to obtain. Now, prior to the change, when the limit was $100,000 for simplified procedure, you would almost never see a claim for loss of income in a personal injury matter that was brought under simplified procedure. And, the questions at discovery that are linked to a loss of income claim are significant. It's an area that we have to spend a fair amount of time on with our questions. And I think we've not seen this yet, but my prediction is that we're now going to get claims brought in the simplified procedure where there are income loss components, which means we're going to have to fit in the questions in relation to income tax returns, employment history, education, attempts to obtain employment post injury, and that sort of thing. And so I think it's going to be challenging just to determine what is actually necessary and essential to the case going forward, and predicting what questions you'll be able to fit into the 3 hours. It's also going to be difficult or challenging to control the plaintiff's responses, because sometimes we're faced with plaintiffs who are very chatty, want to offer a whole lot of information that is perhaps not relevant or necessary. And, if you've got all day on a discovery, you might allow that. And sometimes very important information is obtained through letting them talk. However, when you're limited to the 3 hours alone, I think we're going to have to work harder to limit the responses, and we might not be able to get some of this, just off the cuff information. And lastly, in terms of the impacts that I think we need to consider, the impact of knowing your cost exposure, I think, is a very interesting issue. Now, the fact that we know that exposure for costs, should we proceed to a trial, is limited to the $50,000 plus $25,000 for disbursements, I think, except for in certain situations, of course, and judicial discretion. However, I think that's a very important thing for us to consider should we be looking at whether or not we're going to take a matter to trial. Cost consequences are always an important consideration when thinking about whether or not we're going to proceed to trial on a matter. And there is a certain amount of security in knowing what your exposure is. It's making a decision perhaps with more information than you had before in terms of what the risk is for what you might end up having to pay in the long run. Now, if we look at it from the other point of view, as a defendant, and the fact that we may only be able to receive a cost award in the amount of $50,000, I think that it doesn't impact us as significantly because in reality, the ability to collect on these cost awards, I think, is very limited. And so as a defendant going to trial, you probably, you know that you could receive a cost award where the plaintiff would owe you money, but in all reality, your ability to collect on that in the end is probably very limited. And so you wouldn't necessarily count on being able to do that. So the fact that the costs are limited, I think, is an advantage to the defense side of things. It also makes it such that the plaintiffs have to consider what they're going to spend on disbursements, given the limit of $25,000 on disbursements. So the changes to the rules certainly aren't all negative in terms of how they impact an insurance defense file, aside from the limitation on the jury. I think that these rules could help us going forward. and aside from the fact that the discovery evidence is limited. One of the ways I think we can deal with the limitation on the time for discovery, just getting back to that point, is that we can follow up and do discoveries, do follow-up discoveries after the answers to undertakings have been received. And so, as you know, we request a lot of undertakings during examinations for discovery, and we always reserve our right to go back and ask further questions, pursue it, from what we see in these answers to undertakings. We don't necessarily do that all that often, but it may be a situation where we end up having to do that because we haven't had a chance to ask every question under the sun in the first go around. It may be that we have to go back and do follow-up discoveries once undertakings are answered. And those, yes?
I just wanted to add, I think one thing that we might also see is the kind of the nature of the cases that are coming. With the jurisdiction going up and, going up so high to 200,000, one of the things that plaintiff counsel is going to need to be considering is for those injuries, rather than always maybe claiming for policy limits, as we see so often, but because of the cost consequences, if they fail to bring it in the right place, now with the jurisdiction being enhanced, they may need to make some real conscious decisions about where they see this going, and to make sure they're bringing it in the right forum. And that again, whether that's, whether that actually dictates to we're dealing with more perhaps reasonable assessments of files from the beginning, or if the other way of that is from the defense side, it's just we may see a different way of these cases coming forward. And that again will change the nature of our reporting to you, as we're making some assessments based on the fact of whether this person has actually brought it in the correct jurisdiction given what's on the file. And if there is or is not an income loss, part of it might need to be discussed way at the beginning from counsel, where that was often kept open. That might be something that needs to be discussed right from the beginning from the plaintiff counsel side when they're selecting jurisdictions. So I think the nature of the cases that we're going to see, where it's not always been a significant amount of cases within this, in at least our practice area, we may see more for that reason.
Yeah, and I think it doesn't only apply to cases where they're brought into the ordinary course and they should be brought in simplified procedure. I think now we'll be looking at where actions are started in a simplified procedure when there isn't a loss of income claim, whether they're not, they shouldn't be commenced in the small claims court. There's cases, these slip and falls or trip and falls that are relatively minor cases that are brought now in the simplified procedure. And now with the monetary jurisdiction increased to 35,000 small claims court, perhaps those files should be down there, and the same, it can be used. I've used this in a mediation where I've tried to settle a file saying that we would be seeking costs against the plaintiff if we didn't settle, because we thought that the claim was valued in the small claims jurisdiction. So I think that's something to be considering as well, now that that monetary limit has changed as well, and those minor files that don't have the loss of income claim could be started there. So something that we'll have to do at the early stages, and really evaluate whether plaintiff's counsel has evaluated the case properly.
Yeah, I agree with Jen and Kate in what they've just said in relation to the impact here. And I think it's going to force plaintiff's counsel to take a harder look at what they're really seeking for damages on a case at the outset, as opposed to doing what Kate suggested and just pleading for policy limits. And certainly with the small claims jurisdiction going up to $35,000, I mean, there is a consideration for them to be made there at the very outset. And cases in the small claims court jurisdiction can go from commencement to completion at a trial within a year. And the cost difference, in terms of bringing a case in small claims versus superior court is very significant. So it'll be interesting to see, but I think we're going to see a great deal of these personal injury and even some property damage cases where they're, maybe claiming for excess amounts. I think they're going to start looking at this. Plaintiff's counsel will look at this at the outset, at least that's the goal. I believe part of the goal of the change is for counsel to take a close look at their case at the outset and determine what is reasonable in terms of their damages in the end to decide in which venue to bring it.
And strategically, I think that for the plaintiff's counsel, if they don't want a jury, then it's to their benefit to start it under the simplified procedure rules. Because as Sam said, juries, give usually a fairer assessment of the damages than perhaps a judge alone who knows there's a deeper pocket under an insurance company who can pay. So definitely, I think we'll see the personal injury side going more cases going into simplified procedure.
We have first question that's come in, so please keep sending them in and we'll get to as many as we can. First one's actually just requested for a bit of clarification on the transition period, and so if the changes apply to current cases, and if you have a current case, do you have to bring a motion to have the new rules apply?
Okay, so here's what we've seen so far. On cases that were commenced previously under the regular rules, I've had at least one situation since the new year where plaintiff's counsel has requested our consent to move the matter to simplified procedure. Giving consent to move the matter to simplified procedure if it's at a request of counsel is not a mandatory, and therefore we do not have to concede. We don't have to agree to move it to simplified procedure. And what's interesting, I actually had a teleconference with counsel about it yesterday, because in their letter requesting that it be moved to simplified procedure, they set out all of the limitations. They would limit their claim to the $200,000. We would proceed by way of a 5-day trial with affidavit evidence. And they've indicated, that costs would be limited. And lastly, they indicated that there would be no jury. And that's where I had issue, because I filed a jury notice prior to January 1st, 2020, and therefore I can agree to move it to simplified procedure and still seek to maintain my request or my jury notice. And so in speaking to counsel about this yesterday, he said to me, well, but I don't want to move it if you're going to keep your jury. And I said, well, that's your choice. But he indicated in his letter to me that he was going to be using our, refusal to agree to move it to simplified for cost consequences later. And so I wrote back to him and said, I'm prepared to agree to move it to simplified procedure. However, the rules allow for there to be a jury, and I'm maintaining our right to a jury. And my impression is that he's going to respond that this is, not appealing to him, and it won't be moved to simplified procedure. Long story short, it becomes a situation where you have to agree to it at this point, and the repercussions of not agreeing to move it to simplified procedure will likely only be seen once we get to a trial and costs are being assessed at the end of the day. So there could be cost consequences for not agreeing to move it when the court feels that you should have. But we've not seen motions to move it yet. That's not to say that it's not impossible to have a motion to do that, but it's not happened yet at this point. We're just seeing requests for consent to move.
And I think actions that were started under simplified procedure prior to January 2020, there's still a bit of a gap of understanding in terms of whether they can proceed by way of a regular trial or not, or they have to do the summary trial. And again, that was the example I gave with my colleague. The judge at her pretrial seemed to suggest that they were able to proceed under the old rules, but that may not be every judge. So the rules aren't crystal clear on how the trial process will happen for those older files, and that's just something they'll have to work out at the pretrial conference with each particular pretrial judge.
And just to add to that quickly, just to keep in mind though, as long as you filed your jury notice before the end of last year, and you're still entitled to that jury. So this consent discussion, you can consent to moving it, but you're not automatically giving up that jury, and that's just a key consideration. Whether that's relevant to each case, is it going to be a contextual analysis? But if you get stuck, that's what we're here for. Give us a call.
And the costs those caps don't apply to actions started prior to January 2020. So those ongoing files right now, costs, you can agree to limit the costs, as Samantha was saying, but they're not capped automatically.
Okay, and just to, somebody's asked just to recap on the new limits. So if the statement of claim is for $1 million, then these new rules do not apply. The statement of claim must be under $200,000, correct?
Per plaintiff.
Yeah, so Sarah mentioned at the start that the claim the claim, Sarah, do you want to reply to that maybe?
Sure. So if the claim was brought prior to January, that's fine that these caps don't apply.
Okay. But if there was 5 plaintiffs, then the statement of claim.
So it's a max of 200,000 per plaintiff or as against each defendant.
Right.
The other rules, if there are multiple parties, for instance, the 3 hours for discoveries, if there's five parties, is there 3 hours per each?
It's per party.
Okay.
Yes.
And does that apply for the disbursements and costs as well?
That's my understanding. It's per party. Yes.
Yeah.
Right.
And so I guess just to restate that, if there's a claim that was commenced that is for more than the $200,000 and it's just the one plaintiff, one defendant, your typical claim, there's no possibility of adding up the parties to total more than the $200,000, then it's business as usual. There have been really no changes to that. It's only the cases that are $200,000 or less per party.
And one more question that's just come in. So FLAs could also claim for 200,000?
Yeah, theoretically they could, because they would be one of the claimants, so they could separate it that way.
I mean, they likely wouldn't, because if you're claiming just as much as the injured party, I don't see how they get there, but
It would be very difficult to substantiate that.
yeah, but they could do it in theory.
And then in the end, the trial judge will set out damages per party. And so plaintiff counsel may think off the top that they're increasing their claim by, $200,000 by adding in this FLA. But like Kate and Jen just mentioned, it's very unlikely that an FLA claim would be worth that much. And so they wouldn't get it in the end. And the individual plaintiff, the main plaintiff, is still capped at the 200 regardless.
However, I think you could see plaintiffs, usually you'll see claims, if there's multiple defendants, you'll see the plaintiff claims joint and severally against the defendants. Perhaps now you see claims, because it's per defendant, the $200,000 claim per defendant, you see them separating it per defendant, which renders their claim higher than the 200,000. That may be a way that the plaintiff's counsel gets around it. That'd be bizarre, but I think it's provided, you could do it in the rules. So we'll see if that actually happens.
But again, they have to be defensible positions. If at the end of the day, a judge is deciding whether this should or should not have been brought in a simplified procedure, just because you claimed for $1 million doesn't mean that's where it should have been. It should have been brought under original procedure. Now plaintiff counsel is forced to have that conversation. Is this a reasonable space for it to have been in? Can I defend that? And so that's something that, time will have to tell. We'll have to see how it plays out a little bit, how strong a stance judges take on that too, because they're going to want to make sure that they know everyone's in a learning process, as they are themselves, but that again, we're likely to see more of a critical assessment down the line. Whether the first year or so is about feeling these rules out, it remains to be seen, but we expect that really plaintiff counsel is going to have to start looking how they're bringing it, why they're bringing it, and how they justify the manner in which they've brought it now.
And you know what? That was really, that should have been done prior to these changes to the rules. The issue really was that, in a personal injury matter, maybe it isn't that difficult for plaintiff counsel to see their case being worth more than $100,000. The fact that it's been doubled now just makes it such that, it might have them question it from the outset. And so I do think that we're going to see a lot of cases limited to more reasonable amounts of damage requests in order to fall within these simplified rules now than we did before. And I think it's going to become, the norm on a lot of these files, on the files that are not perhaps your catastrophic impairment files, your files that are not, with a significant loss of income claim component, that sort of thing. It's going to become quite common, I think, going forward to see the cases brought and simplified where, it probably wasn't before.
And for property damage files, it may require plaintiff's counsel, and even thinking from a subrogation perspective, it may require insurers and us to quantify those damages, do the work at the outset, look over all of the invoices and everything, and assess those damages to see whether we want to be put into that simplified procedure or not. Because typically we reach, and we say, okay, we'll claim for 500,000. We know we're not there, but we haven't really gone through everything with a fine-tooth comb to look at what our damages are, but maybe now we do on the subrogated matters to see whether we should go down into the simplified procedure rules or not.
Okay, we're getting to the close of our webinar. We'll take one more question that's just come in related to costs and the new cap of $50,000. $500,000.
Yeah, riches.
Right. Do you see that more plaintiff counsel will argue for higher than the current 15% of the damages?
That's on small claims.
So I think what they mean is the way we assess exposure to cost when settling before trial is 15% of the first $100,000 and 10% every $100,000 after that. So I'm not sure that there's going to be a significant impact on the cost negotiations. It's a good point, something that we'll have to consider going forward. I don't know if it's going to have an impact on plaintiffs' counsel and how they try to negotiate costs at the outset or during the negotiation stages. I do know that, you know, the 15% of the first 100,000 and the 10%, you know, every 100,000 after that, in terms of how we calculate it in this region, that's the norm here, and I think it's the norm in a lot of places, but it's certainly not written in stone anywhere. There's no rule providing that. It's just how we proceed. And so it may be that the changes to these rules will have an impact on that going forward.
And actually, you bring up an interesting point about where claims are being filed, and about sort of the differences between the Ottawa courts and the Toronto courts, and what's mandatory mediation. Do you expect these new rules to be treated any differently in different jurisdictions in Ontario?
I mean, the goal of the rules is for them to be applied in a uniform manner throughout the province. And the goal of the rules is to limit the length of these litigation matters, to try and ease up the stress on the courts right now with the volume of matters. But, you know, I just think it's impossible for us not to see some differences throughout the province. When you look at how different regions view different cases, I mean, there's a clear difference, you know, whether you're in the Ottawa region versus the Southern Ontario, Toronto area. And you put that against, you know, Northern Ontario, somewhere like that, that there are clear differences when assessing damages and how the courts deal with matters. So I think there probably will be some differences, but the intention of the rules is to leave very little wiggle room. And so it's left to be seen how much the judge can actually impact, you know, or change or vary from what we see in these rules. And only time will tell, you know, as to whether or not we're going to see some significant differences. But I think this next year is going to be really telling as to how the new rules are seen by the courts and how they're applied by the courts in the various jurisdictions. So maybe we should come back a year from now,
do an update,
and talk to, you know, talk about how we've seen with these changes, because as of right now, we have no practical experience with it. We're just going based on the words of the rules at this point. Okay, and well, we'll end it there. We're just about on time, and so we want to thank you all for joining. We hope you managed to keep warm out there today. It's -21 here in Ottawa on my drive in this morning. So hopefully you keep warm. And if you have any questions, any concerns, please feel free to contact any of us. You've got our emails up on the screen there. We'd be happy to help. And we'll all go through this new growing pains together with the new rules.
Thank you.
Thank you.